Muy buenas tardes para todos. Bienvenidos a este evento organizado por la Facultad de Ciencias Jurídicas en el marco de las rondas nacionales del concurso de competencias de juicios simulados en Derecho Internacional Ambiental que organiza la Universidad de Stetson. El día de hoy vamos a hablar sobre los nuevos sujetos y las nuevas subjetividades del derecho ambiental y del derecho ambiental internacional. Este evento pues será en inglés, entonces a continuación pues cambiaré a inglés y daré las diversas indicaciones. So again, good afternoon everyone and welcome to this event concerning the new subjects of international environmental law, which has been organized by the Economic Law Department of the Law Faculty of Pontificia Universidad Javeriana in the framework of the national rounds of the Stetson International Environmental MOOC competition, whose director and founder is just here present with us, Professor Royal Gardner. Professor, we are so honored to be with you today. Good afternoon.
Thank you. Good afternoon. And it's an honor and a pleasure to be here.
Thank you so much. You know, Stetson International Environmental Mood Competition has had a great impact in our university, but I would say in the Colombian scholarship for the development of international environmental law. So thank you so much.
Well, thank you for everything that you've been doing to support the competition in Colombia, and we look forward to seeing the teams in Florida in a few months, a couple of months.
Yeah, thank you so much, and of course I need to add to all of those viewing on the YouTube channel of our faculty and all our undergraduate students that you are very welcome to take part of the Stetson Environmental Law course, which is of course prepare for the preparation of this competition. So now turning to today's, I wouldn't call it lecture. I actually invite you to have a dialogue, a legal dialogue regarding these new experiences, particularly produced in the judiciary system, in which nature and some animals, rivers, and mountains have been declared as subjects of international law. So the idea of this conversation is to invite you to interact with us in order to reflect on the effects that those developments and judicial developments created by some Supreme Courts and other judiciary bodies have had in the realm of the whole of law as a whole. So in order to start this discussion, we have been discussing with Professor Gardner how to realize this event. So I would be presenting some Colombian experiences to start with, in which some courts have recognized nature as a subject of law. Then Professor Gardner will be presenting some US as well as the Ramsar experience on the matter. Also for 20 minutes, and afterwards we will give you the floor so you can, of course, make questions, comments, critiques, and whatever you want to say in order to reflect on this topic. So you are very welcome to take notes and maybe be preparing your questions. Before proceeding, of course, I want to tell you who Professor Gardner is, although he may not need any introduction, as he is a very well-known and probably one of the most recognized international environmental lawyers in the US, and of course with a worldwide recognition. Professor Gardner is a recognized expert, in particular in wetland law and policy. And some of your recent projects include testifying before the World Bank arbitration panel, advising the government of Oman regarding wetland policy, also co-authoring some amicus briefs on behalf of environmental scientists, and creating interdisciplinary courses that facilitate discourse among experienced scientists, policymakers, and students. Of course, Professor Gardner has a a very long CV after several years of academic and professional work on the field. But what I can say is that he is indeed one of the world leaders on international environmental law. So thank you so much, Professor Gardner.
Well, thank you. That's very, very kind. But a long CV really just indicates that you are old.
Okay, let's proceed. How could I go to my presentation? Okay, let's go to the point. The new subjects of international environmental law. So I'm going to share with you some thoughts about what has been going on in Colombia with regards to this new approach to nature as a legal subject. So do we have I need a friend of mine on the screen. Where is he? Is it possible? Are we good? Should I wait? Okay, while the technical things are being solved, okay, I'm going to make an introduction of what I want to share. So Colombia has been recently known because of some judicial decisions which have been recognizing nature as legal subjects. Of course, among others, we have heard worldwide about Chucho, the bear, who's the guy I wanted to introduce you, and he's going to appear soon, so don't worry. Also, the Amazon forest have been also recognized as a subject of law. We have in the list the Atrato River, which is one of the largest rivers in Colombia, and some other rivers are added to the list. You know, the Cauca River, Coello River in Tolima. So now we have this trend of rivers, mountains, páramos, and also some animals being recognized as legal subjects. So I wanted to share with you what those jurisprudences have been saying about recognition of nature as a legal subject. So are we there yet? We have the presentation. ¿Crees que la puedes poner y esperamos o...? Because I didn't want to go far without showing you what I had prepared for you. Okay, so I have this list of jurisprudences that I wanted to share with you. So now I'm going to use my fingers, just the Chucho bear, spectacles bear jurisprudence. That's one of the first ones. The Amazon forest also being considered as a subject of law. And we have the Atrato River and some other sorts of rivers being recognized as legal subjects, such as the Cauca River and the Coello River. But before going there, I wanted to share with you what is the common background on how nature has been traditionally treated in our legal system. So what has been the traditional approach? And I'm glad that some private law professors are being present at this conference. In fact, the Civil Code, Article 74, establishes that persons are the individuals of the human species. So this concept of legal personality and legal subjectivity has been only recognized to actual people, and that's what the judicial code has been establishing. However, and likewise, in the international realm, law as a whole has been also rolling around the idea of man as the center of all concerns. And I want to bring to you shame I don't have the slides, but I'm going to share with you the Stockholm Declaration on Human Environment from 1974, which was one of the foundational documents adopted for the protection of the environment. And the first paragraph of the Stockholm Declaration states that man is both creature and molder of his environments. Likewise, the 1992 Rio Declaration, principle first, establishes that human beings are at the center of concerns for sustainable development. They are entitled to a healthy and productive life in harmony with nature. So what I want to share with you, particular undergrad students, is that the legal order has been traditionally established from an anthropocentric perspective, where man and where humankind has been considered the center of all concerns, and therefore nature, including rivers, mountains, bears, and so on, have been surrounding the concept of the interests of men. Oh, here it is. So, may I introduce you, audience? This is Chucho. Chucho, this is the audience. So here it is. This is the Chucho Spectacles bear, and this is why I wanted to show you to you. And I brought this bear because this bear has been not only the object of this sort of jurisprudence regarding the recognition of animals as subjects of law, but he has been also the symbol, the icon that has been representing this struggle. So just for you to know, this is Chucho. He's a Colombian spectacled bear. He's alive, by the way. He's 25 years old. Probably he could be, attending university here. He's originally from the Andean region, and in fact is the only living species of bear native to South America. And funny fact, its closest relatives were the Florida spectacled bears that were extincted 11,000 years ago. Chucho was born in captivity, by the way. However, he has been living all around the Colombian territory between zoos and animal care centers all over the territory. However, he became the center of this discussion because what happened is that this bear, who was born in Nariño, is a department located in the southern part of Colombia, with in a region which is more or less similar to Bogota's. I mean, we have kind of a high altitude, kind of a chill weather. So that's where the this kind of Andean bear is supposed to live. However, due to some administrative circumstances, this bear was taken to Barranquilla. And Barranquilla is a coastal city located, of course, by the sea, which is, of course, very hot. And this, of course, furry bear was suffering there at the zoo because of the high temperatures. So one day, actually, a friend of mine, the attorney Luis Domingo, filed an action of an habeas corpus on behalf of Chucho the bear. The habeas corpus in Colombia, for you to know, is a constitutional action in which all citizens can bring to justice the immediate release of a person who has been captive against his will. So, interestingly enough, Luis Domingo filed this habeas corpus before some regional judge, arguing that he was Chucho's lawyer, Chucho's attorney, and that he was requesting an habeas corpus, which is, of course, a constitutional action traditionally only reserved for humans. So in the first instance, it was denied, but the second instance, the judge granted the habeas corpus. And eventually, he decided that Chucho the bear could be considered a as a person. So that's was what happened. However, the story doesn't end well, and I'll tell you that later. So, okay, there we are. So this is the traditional legal spectrum that we have here. So that's why considering nature as a subject of law, of course, is causing some series of controversy. But what happened in Colombia, and I want to tell you that this recognition of nature as a legal subject didn't appear just out of the blue, but it is the consequence of a series of legal background that has been happening. The first thing is that the Constitutional Court, which is the highest legal judiciary in constitutional matters in Colombia, has been creating a jurisprudential line according to which Colombia holds an ecological constitution. So if you Google it, you can find several jurisprudences and decisions concerning the ecological jurisprudence. And so where's that ecological jurisprudence? So it is all around the Constitution. You can see, okay, I'm gonna take this mic out because you can see the screen. So you can see it throughout the Constitution, but particularly through the recognition of the fundamental right as a healthy environment. In 1998, in the early stage of this new generation of the Constitutional Court, the court accepted the dimension, the ecological dimension of the Constitution and the constitutionalization of the concept of sustainable development. A quick remark, Diana and I, together with Rafael and some other colleagues, are producing a research project in which we are defending the idea that sustainability is nowadays becoming the new paradigm of law as a whole, not only of environmental law. And here, of course, Diana, we can, of course, take a nice quote for our research. Likewise, the court points out that it is undeniable that the ecological dimension of the Constitution as a rule of rules confers a totally different sense to a whole group of legal and economical concepts. So what the idea of having a constitutional an ecological constitution is that the protection of the environment is not only confined in those specific articles of the Constitution, but it is enlightening the Constitution as a whole. And basically that we as interpreters should have a systematic interpretation of the Constitution where all the articles, including those of economic nature, ought to be interpreted according to the concept of sustainable development. And as I was saying, this is not a quote from a textbook, but is the Constitutional Court itself. We have some examples of how this idea has been released throughout the Constitution House, such as Article 58 that speaks about the ecological function of property and the social function of property as well. So property is not longer considered as an unlimited concept. Likewise, Article 79 that recognizes, of course, the right to a healthy environment. Quick note, although it is outside of the chapter dealing with fundamental rights, the Constitutional Court has considered that Article 79 systematically has to be considered as a fundamental right, which implies that all constitutional actions can be used in order to preserve it. And of course, Article 333, which refers to economic freedom and how economic freedom has to be limited to the interest of the protection of the environment. However, I have to tell you that the jurisprudence of the Chucho, the spectacle bearer, was not the first precedent where the highest courts conferred the title to legal subject, to nature. It was actually back in 2011 when the Constitutional Court said just this: today, nature is not only conceived as the environment and the human environment, but also as a subject with its own rights, which as such have to be protected and guaranteed. So everybody believes that the Atrato River jurisprudence or the Chucho jurisprudence was the first precedent, but it was actually back in 2011. However, a quick note, this was part of the, let's say, obiter dictum of the jurisprudence, rather the ratio decidendi itself. Afterwards, in 2014, the Constitutional Court said the complexity of the concept of environment recognizes that its comprising elements can be protected per se, and not only because they remain useful or necessary for the development of humankind. So this jurisprudence is also important because it switched perspectives from an anthropocentric point of view, which, as I told you at the beginning of this presentation, was the traditional view, in order to conceive a new ecocentric approach to law at all. And then is when we get to this landmark jurisprudence, and I like to call it the landmark jurisprudence, the Atrato River jurisprudence. Why is that? Because it was the very first time that the Constitutional Court brought this idea of nature being treated as a subject, as well as the idea of having an ecocentric perspective of the law when it was applied to a particular situation. So, remark, the Atrato River is one of the largest rivers in Colombia. It actually passes through the department of Chocó. Chocó is located by the Pacific Sea, and the Atrato River is very important, not only because its natural characteristics, but also because it has an important effect on the cultural conception of ethnic communities that live around the Atrato River. Likewise, the Atrato River has been used for gold mining purposes, of course, most illegal gold mining purposes. So eventually, a group of people brought a constitutional action in order to ask or to request the constitutional judge to protect the rights of the people of the ethnic communities living in the area, particularly because of the pollution being caused by this sort of illegal gold mining activities. So in order to deal with this case, eventually the Constitutional Court came to this conclusion, which was to recognize the Atrato River, its basin, and tributaries as an entity subject to the rights of protection, conservation, maintenance, and restoration in charge of EPM are the public enterprises of Medellin, who were creating some economic enterprises in the area, and of course the state. I want you just to be highlighting what is important from those jurisprudences. Here it speaks about an entity subject to rights. That's the main feature, and likewise that the court is specifically stating which are the rights to supposed to be protected. So apparently is not a subject which could have the same rights as a natural person. The consequence of this declaration was the creation of a guardianship and legal representation of the rights of the river through a collective commission created for such purpose. The pollution of and the treatment of the waters of the Atrato River, and of course eradicating illegal mining and the recovery of traditional forms of subsistence. Then is where we get to Chucho finally. As I told you, 2017, this lawyer represents Chucho in order to ask an habeas corpus. And within the jurisprudence, and this is what I haven't told you, the court said, and this is the highest, the Supreme Court of Justice of Colombia, not the constitutional one. So I want you to see how there's a clash also between the highest courts. It was stated that animals are capable of feeling and suffering, and law protects them, and they should be subjects of law, and therefore bearers of a right to freedom. And that's how the court finally grants an habeas corpus to Chucho, and it essentially justifies this on the provisions of the ecological constitution of Colombia. However, and this is what I wanted to tell you, is that unfortunately, the very same, now the Constitutional Court changed the judge's mind. And at the end, they decided that maybe granting a bear the rights of a person through the use of an habeas corpus action, it could be too much. And then they came to this 2020 unification judgment, and that's what the SU stands for. It's a unification judgment where the court establishes a precedent between all the decisions. It said that wild animals are constitutionally relevant from two perspectives. First, as an integral element of nature, and second, as sentient individuals. So it came down, you know, from being a subject of law to a sentient individual with their own value independently of their ecosystem contribution. So as you would see here in the 2020 judgment, the court came to a middle way. So where the court accepted the ecocentric perspective because it recognized that animals such as Chucho could have a protection no matter their practical use for humans, notwithstanding they couldn't be considered subjects of law, but sentient animals. While some sectors of the legal practice celebrated this judgment, of course, environmentalists were very disappointed. And then we have this Amazon's decision, which is a decision taken in 2018, and here we come back to the Supreme Court of Justice. And it is funny, isn't it, that while the Constitutional Court has been more modest with their developments, and I would say more careful, the Supreme Court of Justice, which isn't supposed to be the highest authority on constitutional matters, is the one who has been more progressive. And this decision, the one regarding the Amazon forest, was taken by the Superior Court of Justice. So what happened? And this is an interesting story. 25 children, originally from the Amazons, from the Colombian Amazons, and living there, were represented by an NGO called De Justicia. And De Justicia filed tutela action, and for all those who don't know, the tutela action is a constitutional action where individuals can bring fundamental rights violations before a judge for an immediate protection. Those children were represented by the NGO, and according to the action, to the tutela action, those children's rights to life, to health, and to a healthy environment, among others, have been violated through deforestation in the Amazons. So essentially, what the action was saying is that both deforestation and the lack of action of the government towards such problem have been causing the violation of such fundamental rights to those children. The case finally came in a second instance to the Supreme Court, and the court said that, and affirmed that it would recognize the Colombian Amazon as a subject of rights. So here it comes to a much stronger language, and that's where I want to bring you. And then it specified that they were entitled to protection, conservation, maintenance, and restoration by the state and the territorial entities that comprise it. And the action added that the lack of action actually was also being in violation or in breach of the international treaties with regards to the to climate change. So to the UN CCC, the Kyoto Protocol, the Paris Agreement, and among others. The decision afterwards brought this community to create a committee comprised both by people from the community and by regional authorities, where they had the duty to reduce deforestation and, of course, greenhouse emissions. The results were essentially summarized in a national action plan, firstly. Secondly, in a document called an intergenerational agreement for the reduction of deforestation, and the amendment of the territorial management plans of the region. However, and unfortunately, as for today, all those actions have not been taken. And the community and, of course, children represented by the NGO have been filing complaints because of that, because the judgment came up with this wonderful discourse. However, it hasn't happened anything in reality. Lastly, then we have some what actually a doctoral student of ours, David de la Torre, used to call the eco jurisprudences. And the eco jurisprudences are the Cauca River, which is, of course, the case in which the Cauca River is basin and tributaries are considered as an entity subject to the rights of protection. As you see, this is a copy-paste of the landmark jurisprudence, but with regards to the environment, it also reproduced the consequences, creating a sectoral, multi-sectoral committee, these guardians of the Cauca River, and also the obligation to submit biannual reports. We have also Páramo Las Hermosas from the Superior Tribunal of Ibagué, also an eco jurisprudence, essentially a copy-paste of the landmark jurisprudence, and the National Park Los Nevados, where the same wording is being used. So, and I'm taking lessons. So what are the required then conditions that brought us to the recognition of nature as a subject of law? So firstly, what I see is that it was needed a whole concept of an ecological constitution, where environmental concerns and the idea was of sustainability was considered as a fundamental right, which was supposed to inspire the interpretation of the whole legal system as a whole. That was needed. Likewise, as Article 93 of the National Constitution, where it is established that all international treaties concerning to fundamental rights and environment comprise the fundamental rights of the Constitution. Secondly, I think that it was essential how jurisprudence took an ecocentric approach, because ecocentric approach somehow paved the way for the development of the idea of nature being considered as a subject of law. How? By considering and recognizing the intrinsic value of nature, which, by the way, was already established in 1992 by the CBD. Likewise, the recognitions of the rights of future generations as an instrument, as an argumentative instrument for the development of this discourse. And you should know that in the Amazon's jurisprudence, remember that I told you that the action was filed by 25 children represented by an NGO. Not only the 25 children were the plaintiffs, but according to the action, the future generations were also plaintiffs. That's very interesting, and the court accepted it. So I think that this idea of bringing what is called in international environmental law intergenerational equity was incorporated in the Colombian system in order to boost this idea of nature as of legal subjects. And last but not least, although this is only an illustrative exemplification, I think the institutional crisis in Colombia has brought us there as well, because if nature had been protected through the traditional means and actions already established by the law, then probably this new idea wouldn't be necessary. So I don't think that this trend would have arisen in a context where everything was going well. So that's essentially what I believe. And I'm just going to leave some points of reflection so you can start thinking and maybe formulating your questions. And what I want us to think is whether is the recognition of nature as a legal subject actually needed. As far as I know, we all have concerns towards environment. And probably that explains why we are attending an environmental legal event. However, what I want us to wonder is whether this new discourse is necessary and whether it doesn't have any collateral effects that may be even more adverse. So I leave you there with the idea of the biocultural rights, which were one of the discourses used by the Constitutional Court in the Atrato River. And I'm gonna also leave you with this idea of the existence of decolonial approaches to nature, which have been included in the Amazon forest jurisprudence. Why? Because it is interesting how judges develop this idea of the Amazons as a subject of rights after recognizing environmental problems as global challenges caused by the irrational colonization of the environment by demand. And it also speaks about how the circumstances of being either a developed or a developing country puts us in a different position. And likewise, and this is a picture of President Petro's speech at the UN General Assembly last year in 2022, where he stood up for the Amazons. And I actually encouraged you to watch this speech with a critical point of view, just to see how this discourse have been creating different instances. In that case, actually, President Petro somehow spoke about the importance of the principle of permanent sovereignty over natural resources and the interdependence of the world drug problems. Just to say what? To say, okay, we are recognizing the Colombian Amazon forest as a subject of law. However, this has to be interpreted in accordance to the principle of permanent sovereignty over natural resources, which means essentially that you, all the other countries, are not even able to get into our country just to try to protect the forest. And likewise, what he said, and he was actually polemic at the time, he said, and the drug problem is a global problem. And if drugs are being produced in the Amazon, and deforestation is being created as a consequence, is because you are consuming drugs, because you are buying them. And if you buy them, of course, there's going to be some illegal economic activities going on behind that. So we are co-responsible with regards to the world drug problem that is creating deforestation and at the end this global situation. So he spoke somehow about what 1992 Rio Declaration referred as common but differentiated responsibilities. So I'm gonna just leave the things there, and I hope maybe now Professor Gardner can share with us what is going on in the US and in the wetlands realm. And I hope you can keep writing your questions and your comments. Thank you so much.
Well, thank you, Professor Cardenas. Again, it's a pleasure to be here, and it was fascinating to hear about some of the developments in Colombia, and I was struck that one of the questions that you ended with was, is this even necessary to promote nature as the subject of law? And what I found interesting about it is that in November at the Ramsar Conference of the Parties, so this is the Ramsar Convention is the wetland treaty that Colombia and the United States and a total of 172 countries have joined. They got together, and at these COPs, these conferences of the parties, they also hold side events at where those are fascinating. And there was a particular side event on rights of wetlands as a component of rights of nature. And so I participated in that. And when it came my turn to talk, I opened with the question, basically the same question, which was, is this necessary? And is it necessary to try to change the legal paradigm? And asked whether the audience was in favor of rights of wetlands. And this is at a wetlands COP. And there, I would say there was a majority that was well in favor of the concept, but there was also quite a few who had some healthy skepticism. And I think healthy skepticism is valuable and important as we consider these questions. So I'll end by coming back to what I talked about in Switzerland at the Ramsar COP, but I also want to talk a little bit about the situation in the United States about this, to provide some background. And it was just a little over 50 years ago when Christopher Stone published what is a foundational law review article called "Should Trees Have Standing Toward Legal Rights for Natural Objects?" And so standing in this context means the right to litigate on your behalf, the right to bring a lawsuit, the right to vindicate your interests. And so that's a question that we are still wrestling with today. In the United States, typically, trees do not have standing, not in their own right. Individual animals do not have standing in their own right. Parts of the ecosystem, such as wetlands, ordinarily do not have standing or legal rights just by virtue of themselves. But rather, they're protected through a series of laws, statutes at the federal level that have been adopted by our Congress. And in the first instance, if someone is polluting a water body, or if somebody is taking action that threatens an endangered species, it should be the government that takes action to protect the river. It should be the government that takes action to protect the endangered species, whether it's a species of bear in the United States or otherwise. But these laws have what we call citizen suit provisions. So if the government is not enforcing, if the government fails to protect the river from the polluters, if the government fails to protect the endangered species from development that will be harming its habitat, then a citizen, an individual, can bring a case on behalf of the river, on behalf of the endangered species. Now, in order to do that, though, the citizen, the person who is bringing the lawsuit, must establish that they are affected in some way. So it's not enough for them to say, the bear is being affected. They have to show how the bear being injured somehow affects their personal interests. And so this is the concept of standing, which in the United States requires that the plaintiff show that they have suffered a specific injury. It could be an aesthetic injury. It could be an injury to their recreational interests, but they must show that they themselves have suffered an injury, and that if they win this lawsuit, that injury will be redressed, that the injury will be remedied in some way. So on the one hand, a person can try to vindicate the rights of the environment, but on the other hand, this concept of standing keeps the courthouse door tightly closed, or at least you have to really pull on the door to open, to get into the courthouse to file your suit. So, for example, you talked about the children who had brought the action to protect the Amazon. In the United States, there have been a series of lawsuits brought by children, often by a group called Our Children's Trust, where this is climate change litigation, and the children are suing the federal government in some cases to say that they have a constitutional right to a healthy environment, but that the federal government has failed to take action to prevent greenhouse gas emissions. And these lawsuits have largely failed based on standing. They've largely failed because the courts have said, this is not a matter for the judiciary, but rather your fight should be in the more in the political arena. You should bring your concerns to the legislature. You should get the legislature or Congress or the executive branch to take action. So nature traditionally has been treated in the U.S. legal system from an anthropocentric viewpoint, protecting it based on the benefits that it provides to people. And we do have these mechanisms to allow people to try to protect nature when the government fails to do so. But we also see a movement in the United States and elsewhere to promote the rights of nature from a biocentric point of view. And so I want to shift and talk a little bit about that. And part of this shift is because there's a dissatisfaction with respect to the status quo, that even though people may have the ability to bring a citizen suit to protect the environment, they think that it has not been working effectively. So there have been attempts to promote this notion or concept of rights of nature as an additional tool, or perhaps as a way to shift one's thinking about humans' relationship with nature. And so the slides I have here come from the side event that I presented in Switzerland. And one of the things I wanted to make clear, especially since this was a general audience, was to talk about some definitional issues, make sure we understood what we were talking about. And so if we talk about legal rights for nature or for wetlands, I mean, typically in a legal context, a legal right implies a corresponding duty. If I have the right to bodily integrity, it means that you have a duty to refrain from harming me. And so if nature has a right, that would suggest that there is a duty to refrain from harming nature, whether you're talking about nature as a whole or some part of nature or some species. It's important to distinguish between natural rights of humans, which is sometimes used to suggest that rights for humans, for people, come from nature, that the rights are derived from nature or perhaps from God or a deity. That's in contrast to rights of nature, where nature itself has rights. The first, natural rights, is a source of anthropogenic rights, the rights of humans. And the second is a biocentric rights-based approach, whether you're talking about the right of an individual bear or the right of a river to exist in its natural state. And some other key concepts include whether you're talking about nature or parts of nature as being a rights holder, that is an entity that is entitled to protection or is a recipient of a duty, which may mean, but not necessarily, but it may mean that it has legal personhood or legal personality, that is the ability to formally enforce its rights. Or it might also be recognized as a living entity, which has different implications, and may not fit neatly into our current legal structure. So let's take a look at a couple of examples, and these really focus on water, on wetland issues. And there are some similarities to what we've just heard about what's going on in Colombia. So Ecuador has been a leader in the rights of nature movement, and there are at least 2 reported cases concerning the rights of mangroves, manglares. One involved a challenge to a shrimp farm that was being run in a Ramsar site in a wetland of international importance. And that case was in 2012, 2015. Another more recent case occurred where the Ecuadorian Constitutional Court found that an infrastructure law was unconstitutional because it conflicted with the rights of mangroves. Now, in both of these cases, the source of the right came from the national constitution, so the foundational law of the state itself. Now, in contrast, in Spain, there's an example where the source of the rights comes from the legislature. And this example involves another Ramsar site, Mar Menor. And this new law recognizes the lagoon the Ramsar site as a legal person, and it creates a monitoring commission. And much like the Atrato River example and other examples, this commission can act as a legal guardian of the Ramsar site, of this Spanish lagoon. And so the lagoon has been recognized in law by an act of the legislature as having the right to exist, the right to protection, the right to conservation, and where appropriate, restoration. Now, the new law also appears to expand the concept of legal standing on who may sue to enforce these rights on behalf of the lagoon, to allow more citizens to bring a legal action on behalf of this water body. There have been, however, a number of examples where the concept of rights of wetlands or rights of nature have been rejected. And so this concept has run into some serious hurdles and obstacles. In Chile, for example, the proposed constitution, Article 103 of the Constitution, stated that nature had a right to be respected, protected, and maintained. And the draft constitution also recognized wetlands as a part of the natural commons that would be protected through a specific office of the Ombudsman for Nature. It also allowed any other person or group to bring legal action to protect wetlands and other aspects of nature. But of course, as you know, the Constitution was voted down, was not approved by the voters. Of course, it dealt with many, many issues, not just rights of wetlands. And so it's unclear to what extent the rights of nature played in the outcome. But sometimes we see that rights of nature or rights of wetlands are approved by local governments, but then it's overridden or rejected by a higher level of government. And we've seen that in the United States. For example, in Florida, where I am from, Florida, you might think, oh, well, Florida is a conservative state. But in Orange County, which is in the center of the state, and the county is a subunit of the state, the voters approved a referendum by almost 90%, an amendment to the county charter, a law that recognized the rights of 2 lakes, a marsh, and other waterways. And in recognizing the rights of these parts of the environment, it also expanded who could sue to enforce or vindicate those rights. So here we have a fairly conservative state, but yet almost 90% of the people in one county voting in favor of this concept of rights of nature. But the Florida legislature, the state legislature, has enacted a law that has removed the authority of local governments, including counties or even voters, to adopt or recognize rights of nature. And so we've seen similar problems in Ohio, where in the city of Toledo, or it's Toledo in Ohio, but in Ohio, the residents there adopted and voted for a Lake Erie Bill of Rights. So Lake Erie is one of the Great Lakes, and so this this recognized the rights of the lake, but a court declared it unconstitutionally vague, and so struck that down. And so the takeaways here, I think, are that there is a growing grassroots effort to promote and support the rights of nature, of nature as a subject of law. And some of that, I think, flows from a dissatisfaction with the status quo, with the legal mechanisms that we presently have. But if the rights of nature or the rights of wetlands is to be incorporated into the existing legal framework, it works best if there is support at the national level, either through a constitution or a statute, perhaps. But when we think about nature as a subject of laws, I think it's also important to think about it beyond rights that may be enforced solely through litigation. And I want to give two examples here. One is out of Australia, where there is a law that was enacted that views the river as a living system. And so this law then created a special counsel that then provides independent advice to the state government and advocates on behalf of the river. So much like they're the guardians of the river. Yes, yes. And you also mentioned capitalism at the end, right? And so one way to think about it is, well, what can we use in the current structure? And there is at least one example in terms of in the corporate context, and this comes out of the United Kingdom, where a beauty company, named Faith in Nature, amended its corporate documents to allow for the appointment of a non-voting member of the board of directors to speak specifically on behalf of nature. And that board member also has the authority to spend money to hire experts to inform and advise the board. So as the rights of nature movement grows, I think we do need to think beyond these traditional litigation approaches. And one question I sort of want to start our discussion with, and I have sometimes heard, it's like, well, if this aspect of nature has rights, if the bear has rights, if the river has rights, does it have obligations too? What happens if the bear attacks somebody? If you say the bear is a legal person and the bear attacks somebody, may I now sue the bear? Or if the river floods or the wetland floods and you say it's a legal person, may I now sue the wetland or may I sue the river? So that's my question for you. Or my question for you. I have some thoughts on that, but I'd like to hear from some others as well.
Thank you. Thank you so much, Professor Gardner, for your wonderful presentation. But now I'll give the floor to all of you in the audience. Maybe if you have some questions, or maybe if you have some thoughts about what Professor Gardner just asked, or about what I proposed you in my previous presentation. So I maybe can share the microphone with you. Do you have comments on that? Vero?
Thank you. Good afternoon. Actually, I had a question because I have no idea how to answer the one you just told us about. But if I had to, I would say firstly that I do not believe they should have obligations. And like the main point of my answer would be that once we're talking about nature, we have to specify that humans are used to be known as the only ones that could actually think. And based on that, and knowing that animals don't have the ability to conduct themselves willingly, they just act by instinct, they shouldn't be acquainted or responsible for their own actions. That would be like my answer to your question. Notwithstanding, I do have another question, and is, if we believe animals do have like these rights of nature and we give them this ability, what happens with all the animals that are just like produced in order to give food to humanity? For example, cows. Like, how can we use this system and relate the need of the majority of people of consuming meat and the rights of the cows and the animals we consume? So how is that? Yes.
Should we take first some several questions after we come back, or do you think?
Sure, no, that sounds good, yeah.
Why don't we collect some comments before speaking? Vale, please.
I wanted to ask because I have some thoughts before about thinking that this perspective is biocentric is a limit, because we will always have an anthropocentric view, because we cannot see nature as nature itself sees, well, nature. So how to know what are the limitations of our views, and how to, in these limitations, make some laws or a normative stuff to really protect animals and nature, but not trying to say that this is biocentric, because we can never be biocentric if we talk about it in a strict way. So how this feeling that biocentric can work is the good path, or having a good like normative system that is anthropocentric, but that works for nature and for animals, because we cannot give nature and animals stuff that we think that we have, because they don't think the same way. The thing that just Bear said. So that's my main like question or issue.
Thank you. Professor Rafael.
Professor, no, thank you. Professor, I have a question. It is, you mentioned a little bit, I think. I think that we shouldn't be focused on the subject, on nature as a subject, on the rights of nature, but we should be better focused on the duties of human beings towards nature. But I don't know if you think it is the right way or not. I mean, what I think is, talking about rights of nature, it is good in a way if it's not other tool to protect the nature, but I think the really right approach should be to be focused on the duties of human beings. Thank you.
Thank you.
Good afternoon. I do have another question. When talking about the decisions from Colombia on the recognition of nature as a subject of rights, sometimes or most of the time, the Constitutional Court has decided that the guardianship and the protection of those rights are entitled on the government and on the state, but also on like indigenous tribes and local communities. This is in recognition of maybe some sort of anthropocentric vision, but I wouldn't think it's negative, because these communities have a very strong relationship throughout history and on the territories they live with that subject of nature. So the court has decided as one of the ways to protect those rights is to give the guardianship to those communities. And I was thinking that in the field of international law, I really don't know if there has been any sort of any tryings of doing this, the recognition of rights to nature or to different subjects of nature. But in the hypothetical case that is recognized, I would like to have an answer maybe, or to think who will be the groups or the community if they don't have like a strong relationship, or they don't have maybe a direct vision of what is going on with those subjects of law and how this could be implemented in the international field.
Thank you.
Yes, well, I do have a question and a little bit of an answer that may be very basic to Professor Gardner's question. I'll start maybe with the answer. I think that we should not take into account any obligation from nature itself, because I think, coming from the same perspective of my partners here, everything that is being talked about and every single nature right that is being taken into account comes out of human activity, right? So if there's no human activity, why should we consider nature rights? If it's not being affected, why does it even start up a conversation? So I think that the argument that nature should also have obligations is just an argument for us to wipe our hands off and just continue as if nothing's happening, because it's just a way to avoid responsibility, knowing that nature cannot properly execute an obligation. And then my question would be maybe to, well, both of you, but how do you think that the current position of the US regarding nature rights is, I don't know, affecting maybe other countries' ability to respond to these same issues? Or maybe, for example, Colombia or Latin America, we do have a little bit of a closer approach to nature actually having rights, but we're not executing it. So like what Fabian just told us about. So we do conclude that we have to have a commission that protects the river or the communities or whatever, but we do not execute it. So do you think that maybe the position of such a big country like the US is affecting that, or how do you think that it's misguiding or guiding other countries?
Thanks a lot. Please. Well, those are some excellent questions and responses. So I will take the easy ones and I will leave the hard ones for you. So to talk a little bit about whether nature should have obligations, I agree with what's been said here. I think that's nonsensical. As a practical matter, I mean, the bear has no money. Although you could, if you were suing a wetland or a river for flooding, you could say, well, in order to satisfy the judgment, part of the river must be sold off or auctioned off. So, I mean, in theory, you could come up with a way where the wetland or the river could come up with the money. But I think Veronica noted, right, that animals act by instinct, right, so that there may not be intent. And so I also teach, in addition to environmental law, I teach torts. And so at least in the US tort system, liability is premised on fault. You need to show that either you intentionally meant to do something wrong or you acted carelessly or recklessly. There are some instances of strict liability or absolute liability where liability is imposed even if you're not at fault. But those are in limited, very limited situations. You could say, you know, children are not held responsible often because they cannot form the necessary intent, or young children can't be held negligent as a matter of law. And so I think you could make an analogy to nature or aspects of nature in that respect. And also there would be defenses that could be raised on behalf of the wetlands or the river if someone got flooded. Coming to the nuisance is a defense. Like, you came to you shouldn't have built your structure there in the floodplain, and thus you'd be entitled to no compensation. Let's see. Professor Raphael suggested that perhaps rather than focus on rights of nature, we should focus more on the duties of human beings, and I agree with that. And although by focusing on rights of nature, sometimes it's being used as a tool to try to prod humans to act in a different way, which sort of gets back to the other point in terms of whether we can really say we're taking a biocentric rights-based approach. And it's probably beyond our capacity as humans to do that. But one of the ways I got involved with this, the rights of nature concept, was through my work with the Society of Wetland Scientists. So I have represented this scientific society and other scientific societies in Clean Water Act litigation. So this is totally separate from rights of nature. This is where we're trying to enforce the Clean Water Act. And so I have filed briefs, legal briefs on behalf of these scientific societies to try to inform judges and courts about some basic scientific principles. And a number of those scientists were so concerned about what they felt was the inadequacies of the current legal system is that they then started to study this rights of nature approach. And that's really where the rights of wetlands concept has evolved from. It was through the Society for Wetland Scientists. So there is this connection with still with trying to focus on the duties of humans, but perhaps taking a different tact to try to convince them. But there are critics of this approach that say, well, this is a distraction, and that we should just sort of focus on using the tools that we have now. So I'll leave it there. Let you answer some of the other questions.
A little bit hard, you know.
Yeah, I mean, what about the cows? What about animals in zoos?
Oh my God, no. Of course, this is almost impossible to answer. But I since we are here together with very close friends, I'll speak my mind out, okay, about this subject.
But we're also on YouTube, aren't we?
Yeah, but we are with our friends.
But they're friends on YouTube.
Yeah.
Okay, all right.
Yeah, but the thing is that so far, I believe that this new trend regarding the recognition of nature as a subject of law has not been proved to be actually effective. And in my view, it has only had a discursive and symbolic effect. That's what I think about those judgments. And I believe I'm gonna get some haters on the internet. And I love nature, I love environment. Of course, I celebrate those judgments because they essentially position the environment in the top of our interests, and that is great, of course. But if we analyze those judgments integrally, they still have some missing parts. And why is that? Because sometimes I just find that those judgments make those affirmations that this river is a subject of law, or this bird is a subject of law, and media usually take out of context those particular phrases and make a headline out of it. However, when you analyze the judgments I just presented, I mean the Atrato River, the case regarding Chucho, the Cauca River, the Amazon forest, all the decisions were at the end made solely based on a human rights perspective. So at the end, all the decisions were taken just in accordance with the constitutional system for the protection of the fundamental rights of the peoples, of the children's, and of the communities. In fact, even the landmark jurisprudence of the Atrato River was based mainly on the idea of the existence of some biocultural rights of the people living in the region. So at the end, I believe that the logic behind those decisions are quite similar to the perspective that Professor Gardner just shared from the US practice, where nature is protected as far as the plaintiff has the possibility to prove that it has been affected in some ways by the affection or pollution of the natural resource. So my view, and I have said these sort of things also in interviews, I believe that the recognition of nature as a subject of law in the Colombian jurisprudence has had only and purely a symbolic effect. And why is that? Because at the end, everything was just built from anthropocentric needs and from procedural rules surrounded by the fundamental rights of the people. Likewise, and I share the same thought with Vale and Vero, I believe that as for today, even the ecocentric approach ends up being anthropocentric, because even this ecocentric approach that has been developed in this jurisprudence is limited by the let's say again, limitations of our human mind and of our human needs. And it kept me thinking, what happens if one day is not Chucho, the cute spectacles bear, who is at stake, but maybe a bunch of rats that have invaded, I don't know, a neighborhood, or some mosquitoes that are probably spreading some serious disease in a population? Is the judiciary still gonna take the subject's approach? And I don't believe so. I don't believe so. And how can we, and Vero brought us, to the discussion, how can we distinguish between cute bears on the one hand and the cows that we use just to feed ourselves? And that is going to be, of course, a difficult situation. So at the end, I find very reasonable what Rafael just said, and is that eventually what should matter is that the duties of humans towards nature should be both very well established and respected. And what this discourse of the new trend of nature as a legal subject is doing is to make an emphasis about the great and utmost importance of the protection of the environment, that it should be at the top of our agendas, both nationally and internationally. And lastly, and with regards to international law, what we see is that nature has either treated as an object when nature concerns or develops within the realm of a state sovereignty, and in that case it is protected by the umbrella of the principle of the permanent sovereignty over natural resources. And that's why I brought President Petro quotes to today's panel. But on the other hand, when it concerns to nature, but nature as global challenges such as climate change or the high seas, it's being considered as a res communis, or a common heritage of humankind. But even in that perspective, nature is still being treated as an object. You know, is res community. Res actually means object. So I don't believe that not even in international law has been a practical exercise of treating nature as a legal subject. And if you see the experience both of Colombia but also of other places of the world, just Ecuador and in India, the Philippines, what they at the end wanted to do is to create commissions and ways of managing those natural resources, but at the end, of course, limited to the uses and benefits of humankind. So I just leave the question, does even the ecocentrism actually exist? I mean, is it possible, since it is actually drawn by from our human perspective? And I don't know, I have an answer for that. We need to do further research, but at least what I want to leave it is that all those assertions are still challenging and they shouldn't be taken for granted. Okay?
Okay.
Thank you so much, Professor Gardner, for being with us.
Thank
It's
you.
been a pleasure, a privilege. And thank you all for being here. Goodbye. See you next time.